This is a brief introduction to statutory interpretation in California. So first, what is statutory interpretation, or sometimes referred to as statutory construction? I think they're essentially the same thing, and both terms naturally refer to how our judicial branch, that is the courts of this state, interpret statutes, which of course are enacted by bills through the legislative process, or by statutory initiatives through the adoption of ballot initiatives by the state's voters. And these same principles of statutory construction or interpretation are used for all the laws enacted either by the people or by the legislature or even by regulations adopted by the executive branch. So, why is it important to have a basic understanding of how laws are interpreted by the courts here in California? I think that understanding how the courts interpret statutes and, of course, regulations and even constitutional amendments is important to anyone who works with these bodies of law. Costly and time-consuming litigation can obviously occur when there are disputes about, for example, ambiguous legal language. Now, while bill drafters, particularly at the Office of Legislative Counsel, try and focus on concise, clear, consistent language in our statutes, frankly, it's rare that a statute can either cover every conceivable scenario or be perfectly clear in every instance. As a result, those working with statutes and regulations should understand how the judicial branch of the state and federal governments, for that matter, interpret the laws enacted by the legislative branch and adopted by the executive branch or the people. Now, the courts at both federal and state levels usually begin with what they call the plain meaning of language. In other words, what does that provision of law mean to the average person? If the law is clear and can be applied without the need for interpretation, then the so-called words on the page will dictate the outcome of any dispute or question. On the other hand, if there exists ambiguity, meaning that the words are subject to more than one reasonable interpretation, according to the California Supreme Court, then the judiciary will do things like apply principles of statutory construction or interpretation. Now, the judicial branch can consider both extrinsic and intrinsic aids. The extrinsic ones are materials used during the legislative or regulatory consideration of the law changes. And intrinsic aids are really the changing language of the statute or the regulation as they wind themselves through the legislative or regulatory processes. And the use of these aids, as well as canons or principles of interpretation, are designed to understand what is the intent of the legislature or the regulatory body, or of course the people when there are ballot measures. There are also some different schools of thought regarding the interpretation of statutes. For example, there are judges who call themselves textualists. And that means that you are focused on the text, on the words of the text, and they really don't deviate from what are those words on the page, the statute or the regulation, etc. There are also what we call intentionalists, and those judges try to focus on interpretation based upon the intent of the legislature or of the drafter of the statute or regulation. And then finally, there are judges who call themselves purposivists. And the idea there is that they are interpreting laws based upon the general purpose of the language of the statute or regulation. So they care about the purpose. In interpreting statutes, again, as I've mentioned, the judicial branch uses canons of construction. And these are generally in two main categories, what we call semantic canons. Some refer to them also as linguistic canons, and then substantive canons. So the semantic or linguistic canons are basically presumptions about the use of ordinary language, such as rules of grammar, whereas substantive canons are generally described as presumptions for or against certain outcomes. Now, in most instances, judges in this state rely upon the text of the law, sometimes starting with a dictionary. maybe even two or three as they begin their analysis. The courts generally try to appreciate that the legislature uses words in a statute for meaning and that they act intentionally in choosing the language that they place in statute. And so courts generally avoid reading extra language into a statute, for example. And when there's ambiguity, of course, the courts in California try to ascertain the intent of the legislature. The benefit of canons and their use, of course, is that the legislature, when drafting statutes, understand those canons. The courts regularly use them. Of course, regulated entities will also be aware of them, and that should, in theory, give some level of predictability when statutes and regulations are being interpreted. Ultimately, courts often turn to legislative and statutory history. Statutory history is how the statute is evolving, how it has evolved through the course of the legislative process. Of course, language changes, amendments, some is repealed, etc., versus the legislative history, which is the consideration, such as what is written about in committee and floor analyses. So both legislative history and statutory history can be considered by the courts in the state when trying to ascertain the legislature's intent. So again, just a little introductory comments on in broad terms of statutory interpretation or construction here in the state of California.